Hello, I'm Mashood Iqbal and I'm a barrister at London View Chambers, and today I will talk about judicial review in the Upper Tribunal. As most of you know, that immigration in the United Kingdom is a complex and complicated area of law. It keeps changing regularly, more often on monthly basis, sometimes even on weekly basis. So it is very hard to keep updated with regular changes in the immigration law. Immigration Act 2014 has brought down the number of appeals against Home Office's decisions to bare minimum, that is 3 decisions: asylum, human rights and appeals under the European Economic Area Immigration Regulations 2006. Most of the judicial review applications are against those decisions of the Home Office that are not categorized as immigration decisions within the definition of Section 82 of the Nationality, Immigration and Asylum Act 2002, and those deportation decisions that carry certification under Section 94B of the 2002 Act. The procedure starts when the Home Office makes a decision. Within 90 days of that, you have to file an application seeking permission for judicial review in the Upper Tribunal. An application form needs to be filled in. Grounds of judicial review seeking permission need to be completed, drafted, and the Home Office's decision has to be attached with the application seeking permission for judicial review. Thereafter, when a claim is issued, it has to be served on the defendant, which is normally the Home Office, and then the Upper Tribunal needs to be updated and informed that the claim form has been served. Thereafter, the Home Office has 21 days to file acknowledgement of service. Even if it files the acknowledgement of service, or if it doesn't file the acknowledgement of service, then the Upper Tribunal judge has to decide the judicial review permission application on papers. If the Upper Tribunal refuses to grant permission for judicial review and also certifies the claim as totally without merit, then there is no right to renew the application and to be considered at an oral hearing. Rather, within 7 days, an application can be made to the Upper Tribunal for reconsideration of its decision. Thereafter, if the Upper Tribunal maintains its decision, then an appeal can be lodged in the Court of Appeal, and the Court of Appeal will determine application on papers. Now, on the other hand, if the Upper Tribunal grants you permission for judicial review, then the matter will have to be listed for an oral hearing. And before the substantive hearing and after the permission is granted on papers, the Home Office will have 35 days within which they can file detailed grounds of defence. On the other hand, if the Upper Tribunal refuses to grant permission for judicial review but does not certify the decision as totally without merit, then an application for permission to be considered at an oral hearing, which is called renewed application, can be filed within 9 days. 9-day period starts when the decision by the Upper Tribunal refusing permission for judicial review is sent. Now, when an application is listed before an Upper Tribunal judge, that's where your barrister or your solicitor advocate, whoever has the right of audience before the Upper Tribunal in judicial review proceedings, can make oral representations on your behalf. You do not need to give evidence, rather there is no right to give evidence, because the Upper Tribunal in judicial review proceedings is concerned with the decision making process as opposed to merits of the decision in question. If in the oral hearing permission for judicial review is granted, then again the matter is to go before substantive hearing. But if permission is refused in the oral hearing, then you have to apply for permission to appeal. That you can do right in front of the tribunal. Even if you don't apply for permission, the tribunal will decide your application on its own motion, and in most of the cases permission to appeal to the Court of Appeal is refused by the Upper Tribunal. Thereafter, you have 28 days within which you can make an application to the Court of Appeal directly seeking permission to appeal against the decision of the Upper Tribunal in which you were refused permission for judicial review. That application before the Court of Appeal itself is a lengthy and complicated procedure for which I will have to come back to you in the form of a different presentation. For the purpose of this presentation, this is it, and until I come back to you in the next presentation, take care and I will see you again. Thank you. Goodbye.